every examination being conducted by human agency is likely to suffer from some shortcomings. But deliberate inroads into a framework of the magnitude and the nature as exhibited in the present case demonstrate a deep-seated and pervasive impact, which ought to not to be disregarded or glossed over, lest it may amount to travesty of proclaimed mechanism to impartially judge the comparative merit of the candidates partaking therein. Then, if your lordship may come down to para 21. Conscious are we that as a consequence, all India PMT Dental 2015 would have to be annulled, thereby disturbing the time schedule given by this court in so-and-so judgments, my lords. Though we respectfully subscribe to the calendar of the dates fixed in these cases, more particularly in the textual context thereof, we perceive that in the extraordinary fact situation that confronts us, where the examination involved is vitiated to the core by use of deceitful means and measures to the benefit of some, the consideration of departure from the set time schedule per se would not be a wholesome justification to sustain the otherwise tainted exercise. The time frame fixed by this court in the above case, in our opinion, we are not intended to be inflexibly adhered to in the situation of the kind with which we are seized off. The schedule of dates was fixed so as to streamline and discipline the process of admission by uniform application. So, my lords, in this, my lords, then para 23, we are aware that the abrogation of the exam would result in some inconvenience to all concerned and that some extra time would be consumed for holding fresh examinations with the renewed efforts. This, however, according to us, is the price that stakeholders would have to suffer in order to maintain the impeccable and irrefutable sanctity and credibility of the process of examination, to assess the innate worth and capability of the participating candidates for being assigned inter se merits. So, my lords, in this, your lordships did order re-examination of more than 6 lakh students. My lords, at the cost when 44 was available before them that yes, they are confirmed beneficiaries. And my lords, the last submission in this, which I am obliged to my learned friend to have shown it, there is a statement line, even if one undeserving candidate, this is in para 20, even if one undeserving candidate, a beneficiary of such illegal mechanism, though undetected, is retained in the process, it would be a denial of claim for more deserving candidates. So, when para 20 lordships have said that. Plus, today, the university, plus, there are other players in my petition. Your lordships are only it as of now, because other players as of.
Like what?
Yes, my lord. I have said alternative, if your lordships are not inclined. Because there are many students, 563 students, who had been given question papers late. I have annexed OMR sheets, my lords, in my IA. 220 is the time at which I have also annexed the invigilator instructions. They have to put the time. So there are many students. Nobody knew that they would get a time frame, my lords, for the. And my lords, there is one student, my lords, who has written to them, my lords. That is an individual grievance, my lords. Should I argue it, my lords, now, or your lordship would consider only?
We will not be dealing with him. We are not going to entertain individual grievances at all.
Then, my lords, because
is not the remedy for that. Article 32 is not.
No, my lords, because everything was before your lordship. Now the examination has to start. My lord, the counselling has to start. So, my lords, if the OMR sheet, my lords, I have not been given my OMR sheet, my lords, to my lords. That's one of the prayers. So, I don't want, my lords. My lords, because the.
My lords, I represent.
My lords, then if your lordship is not entertaining, at least give me a chance to go to the High Court as regards that prayer, my lords. Otherwise, then I'll be, my lords, nowhere in that regard.
Yes.
My lords, I represent students from Varanasi, my lords, and we have a distinct stand on the subject. Apart from supporting what my learned colleagues have stated with respect to the reconduct of the exam, my lords, I am also challenging the fact that 1563 students, my lords, were asked to sit for a retest on the 23rd of June. According to me, my lords, that classification or computation of 1563 students, my lords, is totally faulty. And I lay good my submissions on this, my lords. I'm in petition number 384, my lords, writ petition number 384. And if my lord comes to the notification dated the 5th of May, 2024, my lords, which is annexure P3 in my petition, my lords, 3.36 at 384 of 2024. This notification, my lords, crystallizes the problem that was faced on the day of the exam. And this is only one single solitary notification by the NTA, my lords, on the evening of the day of the exam, accepting the fact that only